Article 5, Equality and Non-Discrimination. This section begins with 2 panels highlighting comments. Make sure everyone gets the same opportunities and does not have to fight for them. Hui participant. Having to go to the side door if you have mobility issues, reinforcing the additional needs philosophy. Survey respondent. Introduction. Article 5 affirms that all disabled people shall be given equal recognition and protection by the law. It prohibits discrimination on the grounds of disability and requires the implementation of effective legal protections against discrimination and the provision of reasonable accommodation. General comment. Non-discrimination is a fundamental principle for ensuring disabled people's enjoyment of universal rights. This is reflected by its inclusion as both a principle, Article 3b, and a distinct article in the Disability Convention. Social inequality and discrimination drove the development of the Disability Convention. Where differential treatment or outcomes persist, even in the context of positive progress, this is a signal that further and ongoing work is needed. Importance of Article 5 to disabled people in New Zealand. Discrimination is still present in many different forms and has immense consequences for disabled people and their families. It marginalises the contributions disabled New Zealanders can and wish to make. Better understanding and promotion of reasonable accommodation, including recognition that its denial constitutes discrimination, is key to achieving non-discrimination in New Zealand. At its core, non-discrimination is about the dignity of equal participation. For all disabled people to be free from discrimination, intersections between disability, indigeneity, ethnicity, sexuality, gender or gender identity, and age must be recognised. Communities subject to multiple and cumulative impacts must be prioritised. A recently released report, Counting Ourselves, based on the results of the survey of the same name about the health and well-being of trans and non-binary people in New Zealand, demonstrates that disabled trans and non-binary respondents were more likely to have experienced discrimination than their non-disabled peers and were more likely to have experienced sexual violence. Endnote 44. Current place of Article 5 in New Zealand law and practice. There are some contradictions in the legislative framework with regard to non-discrimination on the basis of disability, with discrimination being both prohibited and, in some cases, legitimised. Disability is one of the grounds of discrimination prohibited under New Zealand's Human Rights Act 1993. The prohibition extends to actions of both the state and private sectors. Endnote 45. The Human Rights Commission, HRC, receives inquiries about and complaints of discrimination on the ground of disability and offers a free mediation service aimed at settling disputes. If mediation is unsuccessful, a complainant can approach the Human Rights Review Tribunal either directly or through the Office of Human Rights Proceedings. The Human Rights Review Tribunal hears claims relating to breaches of the Human Rights Act and can determine if discrimination has taken place. Currently, complainants can experience considerable wait times to have their case heard by the tribunal or to receive a decision. The average waiting time for a hearing is more than 2 years and just under 2 years for a decision, an average of 4 years in total. Endnote 46. The tribunal recently received an increase in resources which may help to reduce waiting times. Endnote 47. Principles of non-discrimination are also enshrined in other parts of New Zealand law, for example, the New Zealand Bill of Rights Act 1990 and Section 8 of the Education Act 1989, which describes the non-enforceable right of disabled children and students to access education. Endnote 48. However, there are a number of acts that seemingly contravene the right to equality before the law and permit non-consented interventions and substituted decision-making for disabled people. Endnote 49. The burden of inequality before the law is likely to fall disproportionately on people with psychosocial or cognitive impairment, thereby creating further disparities between disabled people and leaving some disabled people even further behind. Committee's previous dialogue with the state on Article 5. During New Zealand's last review in 2014, the Disability Committee made 3 recommendations in relation to non-discrimination. Endnote 50. The first recommended that the government reconsider funded family care to ensure that all family members who are carers are paid on the same basis as other carers are, and recommends that family members who are carers be entitled to make complaints of unlawful discrimination in respect of the state party's family care policy. There has been positive progress on this recommendation, with the government agreeing to repeal the discriminatory Part 4A of the Public Health and Disability Act 2000, which deals with family care, remove the prohibition on partners as paid family carers, and pay family members on the same basis as other people providing support to disabled people. These changes will take effect in 2020. Endnote 51. The second recommended that the Human Rights Act be amended to include a definition of reasonable accommodation in conformity with the definition of reasonable accommodation in Article 2 of the Convention. The government has indicated to the IMM that there are no plans to amend the Human Rights Act, as it considers that the court has confirmed that the Human Rights Act is consistent with the definition of reasonable accommodation in Article 2 of the Disability Convention. Endnote 52. In the IMM's view, the Human Rights Act should nevertheless be amended to include an explicit definition of reasonable accommodation, strongly aligned with the guidance contained in the Disability Committee's General Comment 6, Article 5, Equality and Non-Discrimination. Endnote 53. Concerned about the lack of understanding of reasonable accommodation, the Disability Committee recommended that guidelines for reasonable accommodation be properly completed in line with provisions of the Convention and distributed. In light of this recommendation, the IMM produced the guide Reasonable Accommodation of Persons with Disabilities in New Zealand in 2016. Endnote 54. Comment on the realisation of Article 5 in New Zealand. Structural discrimination remains a part of both government and societal arrangements in New Zealand. Disabled people are still frequently positioned as other, as having special or additional needs and, in some cases, limited decision-making capability. Aspects of the legislative framework reflect and reinforce these notions, contrary to a social model of disability. These issues have not been assigned priority attention, nor do they routinely inform policy design. There has been significant improvement in the engagement between government agencies and the DPO coalition. Nevertheless, critical sectors like education, health, justice and housing all maintain structures and policies that fail to provide equal and non-discriminatory access for disabled New Zealanders. For example, disabled children do not have an enforceable right to inclusive education, health services can be provided without consent, and there is overrepresentation of people with mental health and neurodiverse conditions in the youth and adult criminal justice systems. Endnote 55. Alleged discrimination on the basis of disability has consistently been within the top 3 bases on which complaints are received by the HRC, which comprise approximately 1/3 of all complaints received annually. In the 5-year period ending 30 June 2019, the HRC received 2,082 inquiries and complaints of alleged unlawful discrimination on the ground of disability under the Human Rights Act. The following table provides an analysis of disability discrimination complaints received by the HRC in the 5 years since New Zealand's previous review by the UN Disability Committee in 2014. Table 1. Yearly distribution of disability discrimination complaints, excluding complaints related to more than one area. This table has 8 columns, a heading row, 9 rows of data, and a totals row. The heading row, Areas 2014, 2015, 2016, 2017, 2018, 2019, total. The first row, Government Activity, 2014, 159, 2015, 137, 2016, 146, 2017, 105, 2018, 110, 2019, 104, total 761. Second row, Employment, 2014, 79, 2015, 86, 2016, 101, 2017, 100, 2018, 107, 2019, 108, total 581. Third row, Provision of Goods and Services, 2014, 58, 2015, 58, 2016, 63, 2017, 55, 2018, 71, 2019, 78, total 383. Fourth row, Additional Establishments, 20, 13, 30, 29, 22, 30, 144. Next row, Land, Housing and Accommodation, 18, 15, 14, 22, 14, 11, 94. Next row, Places, Facilities, Vehicles, 6, 8, 5, 5, 3, 16, 43. Next row, Qualifying Bodies, 2014, no entry, 2015, 1, 1, 2017, no entry, 2018, 2, 2019, 0, total 4. Second to last row, Vocational Training Bodies, no entries in the first two columns, 2016, 1, no entry in 2017 or 18, 2019, 1, total 2. Last row, Advertisements, no entries in the first four columns, 2018, 1, 2019, 1, total 2. Grand total row, 2014, 314, 2015, 318, 2016, 361, 2017, 316, 2018, 330, 2019, 349. Total, 2,114. End of table. Formal complaints are likely to represent only a small proportion of disabled people's discriminatory experiences, and it is reasonable to suppose there is a link between the high number of employment-related complaints received and the disparate employment outcomes disabled people experience. For example, there is a 47% gap in the labour force participation rates of disabled and non-disabled people of working age, 26% versus 73%, Endnote 56. Engagement with the mediation services offered by the HRC is voluntary, but agreed resolutions can extend to systemic improvements as illustrated in the following examples. Providers of services and public spaces improve the accessibility and safety of sites, including those of significant national importance. An accommodation provider recognized the role of disability assist dogs and sought to increase awareness throughout the country. An electricity company changed its policy for customers with a medical dependency on an uninterrupted electricity supply. Further examples are set out in Appendix 2. The right to make complaints and seek redress for discrimination is vital. A more proactive approach by the government to ensuring equality and reasonable accommodation in all areas of public life would reduce the need for disabled people to secure the right to non-discrimination through individual and potentially multiple complaints. Recommendations. The IMM recommends that the government 10. Amend the Human Rights Act 1993 with a view to strengthening disabled people's right to non-discrimination, including A. Removing or reducing disability-related exemptions. B. Introducing an explicit definition of reasonable accommodation consistent with the meaning provided in Article 2 of the Disability Convention and General Comment 6 on Article 5, Endnote 57. And C. Creating an explicit duty of reasonable accommodation. 11. As a matter of urgency, conduct an audit of existing legislation for conformity with the Disability Convention, specifically the right to non-discrimination and equality before the law, and report its findings publicly, specifically highlighting non-compliant legislation. 12. Develop, with disabled people, a disability discrimination impact assessment tool or framework and apply this whenever new legislation is developed or current legislation amended to ensure systemic processes for harmonising all legislation with the Disability Convention and eliminating any discriminatory provisions.